episode. Today we are going to be talking about the implication of a notice to quit in under tenancy. So I know that a lot of people keep hearing notice to quit, and wonder what exactly is this and what does it mean, what am I expected to do when I receive this, and who should give this, and so on. So today we are going to be discussing that. We're going to first of all define notice to quit. We're going to talk about who should issue a notice to quit and what should be in the notice to quit, and the time, the length, and other necessary things that you should know. So I hope you sit still and listen carefully as we go into today's discussion. So we're going to be starting with what is notice to quit. So a notice to quit plainly is a letter written on behalf of your landlord, or yes, it's a letter written on behalf of the landlord by the solicitor or the lawyer or the agent, telling the tenant that the landlord wants to evict the tenant, or the landlord does not want to continue the tenancy, or the landlord wishes to, basically telling the tenant that the relationship between the landlord and you is about to end, and this notice is served on the tenant. Let's go again. A notice to quit is a letter written on behalf of the landlord, given to a tenant, informing the tenant that the landlord wants to evict the tenant and is no longer interested in continuing the tenancy. So that is what this notice is, just to inform you that as your landlord, I don't want this tenancy relationship between you and I to continue. I think I want it to end because of this so reason. So please, I'm giving you so amount of notice for you to evict and deliver possession of the property back to me. So with that being established, now we're going to who may issue a notice to quit. Like I said, it is the landlord that issues a notice to quit, but he may, through his solicitor, his lawyer, or an agent, issue you a notice to quit. But you have to understand that for a landlord to issue a notice to quit through his lawyer or his agent, he has to have given them a written authority, allowing them to act on his behalf. So if you are receiving a notice to quit and you are not aware of the landlord giving authority to that agent or that lawyer to act on his behalf, you can actually claim that notice is not valid because he has not given any authority. He has not given a written authority to that person to act on his behalf. So basically, a notice to quit is issued by a landlord, and it may be issued through his lawyer or his agent, provided that he has given them a written authority to do so. So now let's go to what should be in a notice to quit. Important, the first thing that should be there is the description of the tenant's name, the tenant's address, the landlord, so that you understand that this notice is between the landlord and you need to have the names stipulated in the notice, as well as the type of tenancy. If it's a monthly tenancy or a yearly tenancy, it should be stated there that it's a yearly tenancy that you hold as a yearly tenant or a monthly tenant. It should also give a brief description of the property, of the premises, which is for example, a 2-bedroom apartment at so the address so, and it should also state the date which the tenant has to deliver possession, because you are giving the tenant a notice to deliver possession. You can't just give a notice without giving a time line or a time when the tenant is expected to deliver possession of that particular premises. So now we have established that it has to have your name as a tenant, the landlord's name, the description of the premises where you are staying, the where we are talking, the premises in the tenancy, the time frame, the time that you're expected to deliver possession, and the type of tenancy, whether it is a monthly tenancy or yearly tenancy or a fixed tenancy. So once all these are the things that should be included in your notice to quit, and if they are not, it can make the notice to quit defective and invalid. So we might be wondering that on what grounds, like why should my landlord give me notice to quit? Have I not paid? So it depends on if I want to leave. You can't ask me to leave. You can't tell me that you want to evict me. So actually, the landlord, there are some grounds that are stipulated by the law that allow the landlord to give you a notice to quit, to take possession back from the tenant. So the first one is if you are owing arrears of rent. That's if you are owing rent, if you have not been paying the rent, the landlord can issue a notice to quit. Another reason is if there's a breach in the express terms of the agreement. Remember that a tenancy is governed by the tenancy agreement. That is the agreement that you as tenant sign between yourself and the landlord. So where there are instances where the tenant has been breaching this agreement and there has been a warning, or the landlord has made complaints and tenant stops, then the tenant is still not head into those warnings, the landlord can issue a notice to quit, letting the tenant know that he's no longer interested in this tenancy relationship between the tenant. So I need you to leave between this so period. Another thing is if the tenant is guilty of nuisance, if you have been constituting nuisance, maybe you are blasting music and it is disturbing the entire compound, the landlord has a right to issue a notice to quit. Or if he finds that the premises is overcrowded and might be dangerous to human life, there are some buildings, there are some premises, or should I say apartments, where the people that are living in that apartment are overcrowded. There are more than the amount that should be, there are more than the amount of people that should reasonably be living in that part of apartment. If the landlord finds that is going on, the landlord has a right to issue a notice to quit. Or if the landlord is desirous of renovating the premises, and such renovations would actually not be able to go on if people are presently on the premises, the landlord also has a right to issue a notice to quit. So these are basically the grounds and reasons why your landlord can decide to issue you a notice to quit. So and it's important to know that there is a length for this note in which this notice must subsist, and it is usually governed by the tenancy agreement. That is where you agree between your landlord that if there is going to be a notice, it should be for a particular period of time. But where there is no express agreement between yourself and the landlord, the law comes in play, and the law stipulates the length of notice, and this length of notice depends on what type of tenancy you are in. It could be, if it's a tenancy at will or weekly tenancy, you have a week notice. If it's a 3 months, if it's a quarterly tenancy, you have 3 months. If it's a monthly tenancy, you have a month's notice, and if it is a yearly tenancy, you have 3 months notice to quit. While if it's a fixed tenancy, your landlord does not entirely require to give you a notice to quit. He can only give you a 7 days notice for intention to recover premises. So let's go over it again. So if it's say tenant, if you're a tenancy at will or a weekly tenancy, a week's notice. If it's a quarterly tenancy, 3 months notice. If it's a monthly tenancy, a month's notice. And if it's a yearly tenancy, 6 months notice. So you need to understand this length, this periods, this length actually very important, because if a landlord gives a notice and this notice is a day short, makes the notice to quit defective and invalid. So he cannot raise, you can't say that you were actually giving notice to quit. So this dates, this length must be strictly followed by the landlord. So with that being established, now let's move to the main thing, and what is the effect of that notice. The effect of the notice to quit is that you are expected between that period of time to before or on that day, which is going to be stipulated in the notice to quit, you're expected to evacuate the premises and deliver possession to the landlord. And it's important for you to know that because you've been issued a notice to quit doesn't mean that throughout that period you are not expected to pay rent. You are still in possession of that premises. So till the end of that length, you are expected to still. So once that day on the notice, once it's that day that the landlord has given, once the date that is written in the notice for you to give possession is expired, you are expected to give possession. You are expected to leave, and if you are not in that, if you are still found in that premises during that period, you are no longer a tenant, you're more of an occupier. And if your landlord after that period, and if at that period the landlord has the right to also issue a 7 days notice for intention to recover back the possession of the premises. So it was after that 7 days that you still do not give up possession, that your landlord can take you to court and can get an order from court to recover possession. Let's take note that landlords do not have a right to come into your apartment and evacuate you, or come into your apartment to forcefully evict you, whether with police or heavily loaded men. No, they don't have a right to do that. A landlord, no matter how long you have been on that premises, no matter how long you are defaulting in your paying your rent, the landlord cannot forcefully evict you from the premises. So that's another thing to take note of. So now that we know the effect of a notice, let's talk about how to know when a notice is defective. So the first one is when the landlord's agent or lawyer issues a statutory notice without the landlord giving them a written authorization. Like I earlier said I already discussed that your landlord may issue a notice to quit, but he has to give a written authorization. So once he doesn't give a written authorization to his agent or his lawyer to act on his behalf, if a notice is given to you and they have no authorization to do that, that notice is invalid and it is not effective. Another point is where the notice is given is less than or shorter than the statutory prescribed length. Like I said earlier, that the lengths are very, very important. So even if it's a day shorter, they are not effective. If the length is supposed to be for 6 months, and the length which the landlord has given you, if it's a yearly tenancy, it's supposed to be for 6 months, right? And if your landlord defaults in going on and following that law that says it must be 6 months, that notice to quit is not effective. And another point is in some states aside Lagos, like in Abuja, where the notice does not expire at the eve of the anniversary of your tenancy. it is invalid. So the eve of an anniversary of your tenancy is the day before your tenancy ordinarily your tenancy agreement is expected to expire. So if the notice does not end, if the length of the notice doesn't end at that eve, that notice to quit is ineffective and not valid. Another thing is if the date of expiry of the notice to quit is not written in the notice to quit, it is ineffective and cannot be used. And if there is a misdescription of the premises, if peradventure you stay in a 2-bedroom flat at so, but in this notice to quit it states an entirely different address or description, then that notice to quit is not effective. And if the description of the tenancy, that is if it's a monthly tenancy but it states it's a yearly tenancy, or if it's a yearly tenancy and it states that it's a fixed tenancy, it's also, that notice to quit is also ineffective and cannot be used. So basically these are the little things that you should know and understand about a notice to quit. And you should understand that a notice to quit is more to protect the tenants from mean, or should I say wicked, landlords who feel they have the right to evict the tenant at any period of time, at any time. So you need to know that as a tenant you have a right to a particular length for which a notice to quit can be given to you, and the implication of this notice to quit, what this notice to quit means. I hope we're all able to learn something and then jot down some things. And if you have any question, please you can leave it in the comment section. Hope you have a lovely day. Thank you very much.